presenting on the defense side does not mean na hindi namin ina-acknowledge na may mga namatay. What is he exactly trying to imply in that sense?
What Kaufman is trying to imply out of those evidences is that those killings were, of course, justified out of self-defense because because according to his evidences, even without arms, the victims really tried to fight back. Well, when in that case, it in that case it wasn't, to be honest. So,
Mhm.
with those evidences, he he framed the methods of the war on drugs as justifiable because it was under the command. It was under the permission of President Rodrigo Duterte himself that they should kill
Mm.
all addicts and pushers combined. And as you can see in the data here, yes, and Senmo, thank you. So drug personalities were arrested 97%, and there were 3% deaths in operation. While he frames this as a successful uh, operation, it does not mean that even after Duterte's time, the same problems that he had during the war on drugs stopped. It still continued.
And I want to go back on that on that slide as well from Nicholas Kaufman kanina kasi parang mas maraming nag-surrender kaysa sa pinatay. But are there are a lot of deaths that were broadcasted on the news na hindi naman siguro kasama diyan, or is it a war against the poor, or is it like what exactly is the defense trying to imply? Bakit okay, bakit ganyan? Sa accomplishment report, I believe that was from the accomplishment report. Pero bakit parang pinapakita nila na mas maraming um, mga buhay na surrenderies that were kind of aiming to be reformed by um aiming to be reformed eh. So, paano yung ano nito? 'Di ba may mga programs dapat for substance abuse
Mm-mm.
rehabilitation, pero bakit
Yes.
may mga namamatay pa rin, 'di ba?
It's because his war on drugs approach is, of course, brutalistic in its sense and authoritarian.
Because
It
it was a
did not
state policy.
also that. Thank you, Athena. It was, yeah, I want to add to Athena that it was not just a state policy from President Rodrigo Duterte himself. It's also because that prison is that those alleged suspects that Duterte caught, they weren't they they never had the chance to speak for themselves. In that state
Mhm,
policy, as Athena mentioned, uh disguised, yeah, the state policy, or in that case an illegal form of executing criminal, is disguised as the law, and the it blurred the line between respecting human dignity and knowing who is innocent and who's guilty.
mhm. And, I actually want to ask this kasi, I'm browsing my Twitter right now, and, the fact that if you look at the graph, please show this picture. We need to show this picture.
Yes.
Yeah, that one. If you see there are 5,281 deaths in operation noong time ng war on illegal drugs. Is not
Yes.
is it enough to provide probable cause na ito nga ay crimes against humanity?
It is a probable cause. It is a probable cause that Duterte did Duterte did violate crimes against humanity. Why? Because we have data here in front of us. drugs personality arrested, okay. Anti-drug operations conducted is a lot, 123,000, and you have 176,000, and the 5,221, that's its operation. Okay, the good thing is the numbers are here. What I want to question, if I was there, I want to question to Hoffman, who are the 5,281? Who are in the 5,281 deaths? Are
Mhm.
these people the drug lords that Duterte vowed to go after, or are these the
Mhm.
people that we saw in the ICC's footages? That's
Gi
what we need to consider.
Mm.
given the assumption na sinasabi ng iba na, tawag dito, na yung iba diyan pinatay lang naman ng mga vigilantes and yung iba is
Mm,
collateral, you can't make 5,281 just by just ano, kumbaga sa ano, you can make up a total of 5,281 for only just a collateral and collateral damage or whatever it is na EJK lang. I mean, yeah,
Mhm.
it is not explicitly mentioned na it was a state policy to literally kill these drug pushers or users or whatever it is. Pero napakalinaw naman kasi na mula dun sa mga ebidensyang ipinakita ng prosecution ay meron ngang kumbaga sa ano, hindi man wala mang legal na papel na sinasabi para dun sa pulisiyang iyon, ay mahahalata mo naman na technically it was a system that Duterte is willing to implement. At yun yung
Mm.
sana makita ng iba na hindi naman 'to usapin lang ng pagpatay ng mga
Mm.
adik. Totoo naman, tawag dito, delikado tayo sa mga adik, pero hindi aksidente, hindi collateral ang 5,281 dahil definitely karamihan sa mga numero na 'yan ay hindi naman talaga gumagamit ng drugs.
Okay, thank you, Athena, for that. Um, that was Athena, our um one of our analysts dito sa ating panel. Um, kasi kung makikita nyo, these are only, I believe, the police's these are only the police data regarding these anti-drug operations. Pero kasi merong mga independent data that state that there are more than these 5,281 deaths. Ano ang tinatry, ah, anong tinatry na parang ipakita dito ni Nicholas Kaufman to dispute the prosecution's claim that there was more than 5,000 deaths? I want to go to you, Anima, first. Okay,
I'm sorry,
sige, babalik.
Nakamute pala ako.
Ayan.
Kindly repeat po ulit, Nido.
Kasi 'di ba, may
Mm,
independent data ang prosecution na mas
yes.
marami ang namatay noong, kasagsagan ng drug war versus what, the defense is showing, that is from police data stating na 5,281 lang ang mga
Mm,
namatay doong, kasagsagan ng drug war. And what is, are there like any merits to that? May na collateral damage lang ba talaga, or is it
okay.
gonna be something else?
Okay,
How will they
so
contest that?
we are looking at statistics here, and as a psychometrician myself, this is where my expertise comes in, especially when it comes to psychological assessment. Well, in this case, you have the statistics of the anti-drug operations. You did mention about the statistics. Can you repeat again yung statistics na binanggit mo? I do remember that 5,281. Yung nabanggit na ano, yung mga namatay sa war on drugs. What I am concerned about is what kind of sample size did they get to assume or conclude that the data is legitimate. Because there are some factors to consider when it comes to statistical data, which is the source, which is the demographics of the, in this case, the demographics of the victims, the demographics of the suspects. Sino dito yung legit na ano, sino ba dito yung legit na kriminal, sino ba dito legit na drug pusher, sino ba ang drug addicts? You should differentiate between the two. And you have a data
Mhm.
here that fails to differentiate the difference between the two. And the result of that is a
Mhm.
sample size that mixes both and fails to distinguish which which was arrested, which was killed during those anti-drug operations. So this is honestly the blurred line that I saw. This is the blurred line that I saw with Kaufman's data. To be honest, and with the 5,281 deaths in operation, there should be legitimate statistical data that would prove that it indeed happened. But in this case, considering that he had no sources, we can conclude that this may only be hypothetical data, which implies that we cannot conclude if the data that they have is true.
And you brought up, you brought up the fact kasi na ng sample sizes.
Yes.
Kasi if you remember that the prosecution brought up only 49
Mhm.
of the cases of the most notable cases regarding the war on drugs,
Yes, 49
when there's
cases.
so much more that the prosecution could have brought up. And ano
Mm.
ang pagkakaiba ng presentation ng defense sa prosecution dito sa sample size, and with regards to how many were killed during the war on drugs campaign?
Okay, here's the difference between the presentation of the ICC versus Kaufman's presentation. What I noticed, because from the ICC, their evidence was concrete based, was empirical based. Empirical means out of experience. That is why they were able to get footages from various war on drugs victims, and you have the graphic images of those who were killed during the war on drugs campaign, which is solid evidence. And secondly, they did not just show statistics of the war on drugs, but also show demographics, sample sizes, especially the charts, the statistical charts that proved how impactful or how significant the war on drugs campaign affected the Filipino people, especially those in Manila and Cebu, as we have seen, as no, not yesterday, but a day ago. In that case, on day two, compared to Kaufman's data, we can only see that he showed paragraph or text from what Duterte said, and only sample sizes expressed through bar graphs or charts. While that is sufficient because he used quantitative data, it does not underlie the fact that the ICC used a mixed method here, which is qualitative and quantitative. Quan- when you have two methods merged into one, you have a solidified evidence gathered into one, because they are not just out of experience, but also they're based from a specific sample size, which are the war on drugs victims. While Kaufman, in this case, generalized his sample size, but did not distinguish who are the war on drugs victims and who were the people involved, especially with the rest of the drug personalities and the anti-drug operations conducted. Hoffman failed to differentiate who the demographics of his data, while the ICC expressed those demographics in the data.
Mhm. And an argument na sinabi ng defense dito sa kanilang presentation kanina ay neutralization this is a quote from Kaufman's presentation kanina. We, the defense, can show that the term neutralization can only mean the use of self-defense where officers' lives are endangered. The policy of Duterte himself was for the police to use lethal force only in self-defense.
Yes.
So, what exactly is self-defense, and can it be proven in court that yung ginawa ni Duterte, especially for a crimes against humanity case, can be proven as self-defense? Is it enough?
Okay, so I did my quick research, and according to my research, so according to Oxford Dictionary, self-defense is defined as the defense of one's persons or interest, especially through the use of physical force, which is permitted in certain cases as an answer to a charge of violent crime. Which is ironically contradictory to what Duterte pertained na nanlaban yung mga kriminal or yung mga addict na na na-encounter ng mga police. If that was self-defense, how come the victims were unarmed? And secondly, how come the police were the only ones armed while those arrested did not have any armory when they fought back? That's something to think about, Mido.
And when you think about it, they planted drug sachets na hindi naman nila ginagamit in the first place. So, what exactly uh, does the defense want to prove here na self-defense ang term na ginagamit uh, ng defense laban dito sa mga arguments sa prosecution?
What the defense is trying to imply here because you know, as what the followers would say, yung mga drug addicts dito is sinasabi nilang mga runners, and especially that you mentioned yung mga na the police would plant the evidence on the police would plant evidences on those killed in the war on drugs to prove that they really are drug pushers, when in fact it isn't the case. What they're trying to imply here is they're trying to prove their stance on self-defense, uh even if, as we see right now, it looks bleak, to be honest. It looks
Mhm.
too bleak for the defense to prove otherwise, considering how harsh, how graphic, and how gory the photos and evidences were when we first saw those photos of the of the war on drugs victims, mostly unarmed and sadly framed by authorities.
And you mentioned, no, what is what are they trying to parang kasi 'di ba parang sinasabi nila na ano, self-defense and the use of neutralization. This was also used by the prosecution noong presentation nila na parang nino-neutralize yung mga targets ng drug lord, ng mga small time drug runners, but as you said, there were not really evidences where we could find na the people that were killed were drug users or drug pushers even.
Yes.
So, ano ang dapat na atake dito ng depensa para ma-prove na para ma-prove yung kanilang point, or is the self-defense argument kind of moot?
I would say it I would say it's the self-defense of the prosecution team of Duterte is, I would say, kind of moot, considering that what could back their evidences up, what could back their defense up, is if they had actual evidences, just like what the ICC had. Uh, it would it would be justifiable if they really had accounts from the war on drugs victims, the loved ones of the war on drugs victims. Secondly, any statements from any statements from the victims themselves who nearly were part of the death count in that case. And most importantly, what we should consider here is if they have actual evidences, not just hearsay, not just statistics, that the war on drugs was indeed was indeed uh an approach to defend the people, and why the police self-defended themselves against these so-called criminals. What they
What
need is
about
concrete
din
evidence. Mm.
mm, hmm. What about din yung kanilang well, from I believe from what you're hearing kanina, you
Mhm.
were saying na parang mostly paikot-ikot lang yung, mga arguments ng defense dito. Is that approach enough to to persuade the judges into dropping the case?
I don't think so, Mito, to be honest. When you have when you when you have a defense, for example, that has the same theme over and over, it's not going to convince the panel as a whole. Why is that? They're looking for other substantial evidence that would prove that the war on drugs was a success, when in fact it o- what they only saw is one single narrative. That one single narrative is that, one, they blamed the media for the misinterpretation of the war on drugs. Two, I want to emphasize that I want to emphasize those statistics that you mentioned earlier. The anti-drug operations, they mentioned that during those operations from 2016 to 2019, 176,000 drug personalities were arrested, 123,000 anti-drug operations were conducted, and 5,281 deaths in operation. While this is statistics, like I said, if they did not identify where these numbers come from, this statistic would be marked as insufficient if they do not have the actual sample size or the demographics of whoever of the participants involved in the statistic. And third, most importantly, is the effectiveness of the war on drugs. They boasted that the drug personalities arrested were 97%, and the deaths
Hmm.
an operation is 3%. However, what the flaw of this is that we can see from the ICC's data is that those from the those from the lower class are often the most vulnerable, and they're the least likely, as said by Attorney Joel Butuyan, they're the least likely to fight back through through affidavits, for example, or through legal cases against the administration, since they lack the money to do
Mhm.
so. So as we can see here, there's so many defenses that Kaufman tries to justify to frame that the anti-drug operations or the war on drugs was a success, when in fact it was indeed ineffective.
Maraming salamat, Anima, at magbabalik muna ang koolNews special coverage ng confidential charges hearing kay dating Pangulong Rodrigo Duterte matapos ang ilang paalala.
Seryosi, galaw-galaw.
Innova Power G6. Fast, sleek, reliable, affordable. Now equipped with Ryzen 7000 series CPU, Radeon RX 7000 series, 1TB SSD storage, and 32GB RAM. Enough to fulfill your needs.
Innova.
Inspire any Filipino's choice. Introducing O-Spend Mineral Water, made from 100% pure mountain water. Distilled, fresh, approved by Filipinos.
I choose O-Spend Mineral Water.
Wala kaming commercial. Pwera na lang sa commercial nito, oo. Oo naman. Pero, meron ba kaming bagong produkto? Meron ba kaming iaalok sa inyo? Meron ba kaming kinuhang artista o sikat na personalidad para i-endorse kung anong mang inaalok namin? Siyempre, ang sagot niyan, wala. Literal na wala. Wala kami niyan, Chong.
It's morning sunrise. It's time to buy another bread. Guyanese original panenday, made from real wheat flour, sugar, milk, butter, salt, all, and yeast for better taste and better smooth, fluffy, and extra soft. Price only at 20 pesos for 10 pandensal and 40 pesos for 20 pandensal. Available on Guyanese Bake Shop and other bakery stores nationwide.
Mira drinking water. Fresh, cool, calm.
Guyanese maple syrup para paglalagay ng pancakes at waffles sa mas matamis. Sarap.
Presyo sa 300 pesos lang. Magbibili sa lahat ng Jor Supermarket, mga grocery stores, department stores at sa lahat ng mga inyong tindahan.
Hay naku, nakaka-stress talaga ang traffic. Tingin ko sa bahay, napahiga na lang ako sa sopa. Yun tuloy, sumakit na ang ulo ko. Reset.
Headache? May solusyon dyan. Introducing PD Pharma Paracetamol Anti-Fever Capsule. Bukod sa lagnat, panlaban din yan sa sakit ng ulo. May bisa ng paracetamol para balik sigla ka na mula umaga hanggang gabi.
Ayos na ng pakiramdam ko ah. Salamat sa PD Pharma Paracetamol.
Basta paracetamol, hanapin ang nakatatak. PD Pharma.
Ang pagiging news anchor at journalist, hindi biro ang naging trabaho ko. Mula sa aking pagbasa ng script hanggang matapos ang aking newscast. Hay nako, nakakapagod talaga. Ang saklap pa. Buti na lang, I discover Meralias Cola.
Ang inumin na ito ay may iron, taurine at B vitamins. Dinagdagan pa ng fiber.
Pagkainom ko pa lang, ang sarap. Refreshing talaga at sulit pa. Wow, ayos to sa akin. Kapag masigla ang ating araw, mag-Meralias Cola na tayong lahat.
Sulit na, refreshing pa. 15 pesos pa rin.
DM Products Corporation.
Kahit saan, sisig ng ina mo. Lunod ka sa saya, mula sa pampagana hanggang sa dulo.
Ang sisig na hinahanap-hanap mo ay nasa sisig ng ina mo na. For just 70 pesos, may legit na kapampangan na sisig ka na with soft drinks and sabaw. Dito lang yan sa sisig ng ina mo.
Mira drinking water. Fresh, cool, calm.
Innova Power G6. Fast, sleek, reliable, affordable. Now equipped with Ryzen 7000 series CPU, Radeon RX 7000 series, 1TB SSD storage, and 32GB RAM. Enough to fulfill your needs.
Innova.
Pagkagising sa umagang umangon at kumain ng sapat. Gatas ang kailangan para lumusog ang katawan, pero may solusyon dyan. Ito ang MSI Gatas. Uminom ng MSI Gatas.
Ada Morella po, mag-MSA Gatas para iinumin ang gatas. Sarap. Mag-MSA Gatas na. 69 na piso SRP sa suking tindahan.
The use of milk supplements must only be upon the advice of a health professional.
Gummies maple syrup. Para paglalagay ng pancakes at waffles sa mas matamis. Sarap.
Presyo sa 300 pesos lang. Magbibili sa lahat ng DUTERTE Supermarket, mga grocery stores, department stores at sa lahat ng mga inyong tindahan.
Ang boring dito. Hanap na lang kaya ako ng maiinom.
Ang refreshing!
Refresh your day. Feel alive with Chaos Cola. Also available, Chaos Soda.
Woo! 25 pesos lang. Sulit. Bin na.
Every sunrise brings a new story, and every story begins with a single journey. At Zakish Airlines, we believe travel isn't just about reaching your destination. It's about the experience that carries you there. From comfort that feels like home, to service that feels like family, we make sure your moments in the sky are unforgettable. Because when you fly with us, the world is closer than you think. Zakish Airlines, your world within reach.
Shopee, dua-dua, Tencel, alamin, sel, di Shopee, dua-dua, Shopee, dua-dua, Tencel, alamin, sel, di Shopee, dua-dua, di Shopee, dua-dua, alamin, sel, di Shopee, dua-dua, alamin, sel, di Shopee, dua-dua, alamin, sel, di Shopee, dua-dua, Mencel. Pagkagising sa umagang mangon at kumain ng sapat, gatas ang kailangan para lumusog ang katawan, pero may solusyon dyan. Ito ang MSI Gatas. Uminom ng MSI Gatas.
Ada Moreller po, mag-MSA Gatas para iinumin ang gatas. Sarap. Mag-MSA Gatas na. 69 na piso SRP sa suking tindahan.
The use of milk supplements must only be upon the advice of a health professional.
Dito, kung kailan napagod ako sa trabaho, kakabasa ng script o sa prompter man, at kahit ako'y pagod pa rin, sisigla pa rin ako sa tulong ng Miralles Cola. Miralles Cola lamang ang may iron, taurine at B vitamins. Ayos to ah. Para masigla ang araw nyo, mag-Miralles Cola na.
I'm an all-around media personality. Of course, I read books. Because not only they gave me knowledge, but they're also a form of entertainment. What you're seeing right now are few of the best-selling brands of GSCA Kent Media. At iilan pa yan, marami pa yan ha. Basta, hanapin nyo lang ang logo na to. The Philippines' leading premier #1 awesome publisher GSCA Kent Media. Because reading is indispensable.
Inspire any Filipino's choice. Introducing O-Spend Mineral Water, made from 100% pure mountain water. Distilled, fresh, approved by Filipinos.
I choose O-Spend Mineral Water.
Mabango ang hair. Hindi lang ang hair, smooth pa rin. Thanks to O-Spend Shampoo with 100% natural coconut cream. May long-lasting bango, kaya di lang mabango, bango smooth pa.
Pagkagising sa umagang mangon at kumain ng sapat, gatas ang kailangan para lumusog ang katawan, pero may solusyon dyan. Ito ang MSI Gatas. Uminom ng MSI Gatas.
Ada Moreller po, mag-MSA Gatas para iinumin ang gatas. Sarap. Mag-MSA Gatas na. 69 na piso SRP sa suking tindahan.
The use of milk supplements must only be upon the advice of a health professional.
At nagbabalik ang koolNews special coverage ng confirmation of charge receiving ni dating Pangulong Rodrigo Duterte. I want to interrupt you for a quick bit with some breaking news mula sa Negros Oriental. Sumabog na naman ang bulkang Kanlaon kaninang 7:04 PM ayon sa PHIVOX. may plume ito na na sumabog for 2,500 meters papuntang, pataas at lumiko ito pa timog kanluran. May mga lumalabas na rin na bal mga incandescent ballistics at meron pa ring pyroclastic density currents or PDCs sa, sa silangan at timog silangang upper slopes sa loob ng 2 kilometro mula sa summit crater. Ito po ay sinusundan din natin at the same time while the confirmation of charges is going on, and in a few minutes, we will be hearing once again dito sa International Criminal Court. Anima, if you could help me out again kasi itong mga arguments ng defense, I just want to ask you one last question bago tayo switch ng feed kasi there is a collective mentality, 'di ba, na itong itong rhetoric na ito ni Duterte ay nakapagpa-impluwensya ng marami sa ating mga kababayan to not be empathetic. How do you think how do you think empathy will play a role here dito sa magiging verdict ni dating Pangulong Rodrigo Duterte, whether this goes to trial or not?
How empathy will play a role, I believe, considering that this is a trial, of course, logic should dominate rather than emotions, Mito. Because when you talk about empathy, it means you feel for someone. You relate to someone's feelings, you relate to someone's struggles, and you are aware of what they are feeling. That is the role of empathy. But in this case, considering that this is the trial, of course, of a convicted pro-China criminal, who's known for his war on drugs campaign, and not just the war on drugs campaign, but also for being responsible for his troll farms in this case. I would say that it is valid. It is valid for an ordinary person to either feel or not feel the same for PRD, because we all feel, to be honest, we all feel for someone else. But what can be alarming, especially when it comes to the lack of empathy, is if a person cannot relate to someone's struggles, if a person cannot relate to the reason why they are struggling. It all boils down to the intention, I would say. It all boils down to the intent of a person, and in turn how people will empathize how people will empathize for Duterte, for example, considering the gravity of his case. This is not just about his current state, but the intentions, but the actions he made during his past. I believe empathy is not just going to play a role here, but the evidence over empathy in this case.
Mhm. At sa ngayon ay naghihintay na tayo na bumalik muli ang sesyon dito sa ICC. The defense has presented their submissions of merit for 2 counts of the crimes against humanity case laban kay Duterte. And nasabi nga ni Kuya Pao kanina na kahit isa man lang sa mga kasong isinampa laban sa dating Pangulo ay pwedeng mag-proceed sa International Criminal Court. But I do have another question for Anima. What if it was all free na mag-proceed sa trial chamber? What is going to happen?
Before any of that, good evening to Kuya Gab, who is here with us, Kuya Gab of PTV. And secondly, so how it will affect the wait lang. About that question, can you repeat again? Can you repeat again po?
Okay. Sige. Kasi sabi ni Kaufman, wait. I forgot what I was going to ask. Pero yung defense kasi, they were trying to
What if
ayun.
okay, thank you.
Kasi ano, 'di ba, tatlong counts.
Yes.
And what if all three proceed to the actual trial chamber? What happens then?
It means it is enough substantial evidence for Rodrigo Duterte to be convicted of such crime, to be guilty of such crime in that case. If all those three, are mentioned in the actual trials this Friday, it means that Duterte is indeed proven to be guilty of these crimes that he committed. These three counts in that case, which ICC first mentioned on the first day. So if those three proceeded on the last day, then it simply means that Digong is indeed guilty of his crimes and will and this is depending solely on the jurisdiction of the ICC. Let's proceed to the feed now.
Mhm. But the question is whether if it goes to trial or not, 'di ba?
Yes.
What if it's all free and then doon sa trial and then it goes to trial? It's gonna be tried in the trial chamber then.
And if it will be tried in the trial chamber in this case, it depends on how much evidence the ICC has. It's either that it's either they may acquit it if their evidences are disproven, or they will have to undergo another trial to prove such evidence in that case.
Kasi 'di ba dito sa pre-trial is only to discern whether these evidences are strong enough to kind of go to trial. If enough na ba yun for an actual trial? Like, what exactly is going to happen if it is enough? And then all free, kasi sabi kanina, there's a possibility na baka isa lang yung mapunta sa chamber, sa trial chamber ng ICC. What then if it's going to Okay, I will just cut my question right there kasi inaantay na nating mag-broadcast ang International Criminal Court dito sa huling sesyon ng ikatlong araw ng confirmation of charges hearing ni dating Pangulo Rodrigo Duterte. We're all from the statements kanina that were made by the defense. It seems that they are going in circles. I don't know what will these look like. How will they further prove na how will they refute the allegations made against their client? So we'll see mamaya. We're just waiting now for their feed to switch to the pre-trial chamber 1. By the way, you are currently watching the koolNews special coverage ng ikatlong araw ng confirmation of charges hearing dito kay dating Pangulong Rodrigo Duterte sa International Criminal Court at simulcast pa rin po tayo ngayon sa 89.5 Manila SDR, 96.7 SF Radio at sa official Twitch and YouTube channels ng Cool FM. And it should be going live anytime now. We'll see. And I'm very interested to see kung I believe ito na yung third count of submission of merits for the third count, which is the barangay operations and the murders that happened during these proceedings. So we're just going to can you TOC, can you switch the feed na kahit na ano pa? Thank you. And we're just actually waiting. Kanina kasi nung during the proceedings of the first two submission of merits, nakat si Kaufman and he was scolded twice by Judge Julia Motok kasi hindi po siya nagre-refer sa mga documents na nandoon sa doon sa mga isinumite ng prosekusyon. Abangan natin yung kung magbabago ba mamaya ang stance or ang itsura na magiging approach ni Nicholas Kaufman dito sa kanyang defense presentation. It should be resuming any moment now. We'll see kung sapat na ba ang ginawang arguments ng defense team para i-refute itong mga kaganapan ng itong mga nangyari. Ayan na. We're back in session. Let us listen in to the proceedings.
All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Bonjour à tous.
Judge Modoc, good afternoon. I'd like to begin with an oral ruling regarding the redactions made to the transcript and direct broadcasting today. The Chamber notes that redactions were made to the transcript and to the direct broadcast of the hearing subsequent to an application by the prosecution and which was opposed by the defense. The application of the requested redactions apparently would be a problem and could lead to hearings being held in closed session. The Chamber wishes to recall an earlier ruling during which the Chamber stressed that it is up to the parties and participants to ensure that their submissions are worded in such a way as to avoid going into closed sessions, thus ensuring the transparency of the proceedings and to avoid the disclosure of confidential information. The Chamber would remind the parties to comply with these instructions. Furthermore, the Chamber is of the view that the information that was asked to be redacted and also from the direct broadcast today were limited to identifying information witnesses and victims mentioned during the submissions. The defense disclosed information on several occasions that allowed for the identification of victims and witnesses. For example, positions held and nicknames, things that must not be disclosed so as to ensure the protection of witnesses and victims. The redactions had only to do with identifying information and were not as general redactions to the events within the case. This was the appropriate recourse to implement the Chamber's duty to protect the safety and well-being, including psychological well-being, the dignity and privacy of victims and witnesses in accordance with Article 68 of the Rome Statute, without having to hold the hearing in private or closed session. Thus, the Chamber has decided to maintain the redactions that were applied earlier and reminds the defense not to disclose information that may not be necessary and information that could identify witnesses and victims in accordance with Article 8 of the Code of Conduct of Counsel. I thank you very much. And Mr. Kaufman, you may now proceed and continue your submissions on the merits. You have until 3 p.m. Thank you very much.
President, as you can see, we have a number of yellow post-its on our table here. These are the document identification numbers of all the matters that I'll be talking about. But since we only have until 3 and until 1 hour tomorrow morning, I can provide the ID number if necessary, but I will move on, and we promise to give the Chamber at the conclusion of the hearing the full ID numbers of everything that I've talked about. And if the prosecution obviously wants something as well, he can...
Afternoon, Madam President. I would just ask my friend if he can read out the tab numbers, because every item per the Chamber's instruction has a tab number. So even if my friend doesn't read out the entire ERN of the page he's citing, the lines, if he gives us a tab number, at least we can check his homework in real time.
Merci beaucoup. Thank you very much. Counsel, are you in agreement with this position taken by the prosecution? Well, the representative of the OTP. Mr. Kaufman, yes, ma'am. Judge Motik, please proceed.
Come to ask myself another question concerning the nature of a common plan theory which applies equally to its subjective requirements. Has the prosecution shown substantial grounds to believe that Rodrigo Duterte's implementation of its fantasy criminals scheme was of such a nature that the murders detailed in its 49 charged incidents would have ensued as a virtual certainty in the ordinary course of events, and that he foresaw that they would occur as a virtual certainty in the normal course of events? Let us take a moment so that I can assure you that these wonderful words, virtual certainty, actually do exist in the court's case precedent and are not a fiction of my own. If you will, please display the first of 2 citations from the Abdul Rahman, otherwise known as the Ali Kushaib trial judgment from 2025. First of all, paragraph 795. While the common plan between individuals need not be specifically directed at the commission of a crime, it must nevertheless involve a critical element of criminality meaning that in the context of the specificities of the case, it was virtually certain that the implementation of the common plan would lead to the commission of crimes. We can have a look at paragraph 706, and it talks about the general knowledge requirements, which I am sure Your Honours are very familiar with. So, with respect to the question whether the common plan entailed the occurrence of murders as a virtual certainty, the answer is an emphatic and resounding no. First of all, let us recall what the prosecution defines as the former president's list of high-value targets, what the media calls the kill list, and what one of Mr. Edward Jeremy's quoted witnesses referred to as the dead list. The number of individuals on this so-called kill list, the very list on which the prosecution relies to show that the knowledge that death would ensue, is 4,817. Those who are actually neutralized dwarfs in comparison and stands at 248. So, assuming that neutralized actually means killed, which it does not, then there is no virtual certainty attributable to Rodrigo Duterte that death would ensue from this kill list. Rather, a 5% chance. Let us have a look at a bar chart for exactly the same figures used by the prosecution as distributed geographically. I now turn to the issue of control, as it did or did not manifest itself in the crime base. In other words, can it safely be argued that substantial grounds exist to believe that Mr. Duterte's supposed diktat filtered its way down from his mouth and via his co-perpetrators to those who were supposedly going about committing these murders? How has the prosecution shown the concept of automatic compliance, or even virtually automatic compliance, so essential to its pyramidal structure? Well, by and large, and judging from Ms. Robin Croft's submissions, it would appear that the concept of automatic compliance is substantiated by reference to subjective comments made by perpetrators who talk about their will being controlled. For example, transcript, page 37, line 7 onwards. I felt like that I didn't have any choice but to follow their orders. It wasn't possible not to obey his commands. Another example. Transcript, page 38, line 17. Co-perpetrators controlled the will of the physical perpetrators. End quote. According to the prosecution, members of the Davao Death Squad had to seek clearance from Mr. Duterte to conduct killings in Davao City. For this wild assertion, the prosecution relies once again on the evidence of criminals it has recruited, all of whom are inherently unreliable because of their being self-confessed vicious murderers, testifying in return for virtual immunity from proceedings at the ICC. We shall analyse the testimonies emanating from these individuals in detail later in my submissions. Now I can see Mr. Nichols scribbling away there, but I shall be referring to what are called statements of limited use. As for the other modes of liability charged, ordering under Article 25(3)(b and Article 25(3)(c, aiding and abetting, as I have said, no smoking gun, no evidence of a direct order, solicitation, or inducement with respect to any one of the 49 incidents. No documentary record exists of a presidential order. So how could these orders have been transmitted for the purposes of Article 25(3)(b? Well, unless Mr. Nichols envisages mental telepathy, I think that we can discount ordering. The prosecution has failed to elaborate in its oral submissions what it means truly by soliciting. If it means the ambiguous public speeches, then it is difficult to reconcile the frequent exhortations to self-defense with soliciting, unless, of course, you accept that Mr. Duterte super craftily inserted these exonerating comments into his speeches in order to craft himself a defense when the day of reckoning would come. As the prosecution asserts, speaking with a forked tongue, sometimes speaking his mind, sometimes saying what he wants you, your honours, to hear. Furthermore, generalized statements months before specific incidents do not establish causation or instruction. For aiding and abetting, there is no reliable evidence that Mr. Duterte provided practical assistance, encouragement, or moral support that substantially affected the commission of a crime, with knowledge of the perpetrator's intent. And finally, on modes of perpetration, modes of liability, I would beg you not to take heed of Ms. Paulina Masseda's assertion that Rodrigo Duterte failed to prevent or punish. The prosecution has not charged command responsibility under Article 28. And the reasons for that are clear. It is the same reason why it cannot prove ordering. There is no ascertainable chain of command descending from Duterte at the top, via the co-perpetrators, so-called co-perpetrators, all the way down to the crime base. As I said, it all breaks down at the level of the co-perpetrators. And I would ask you very respectfully not to exercise your discretion to requalify pursuant to Regulation 55 of the regulations of the court. But if you do, and you shouldn't, I respectfully submit, you should order the prosecution to resubmit its document containing the charges and its pre-confirmation brief as amended, and to release Mr. Duterte in the interim. Now, I have finished that section of my submission, and I will now turn to the witnesses themselves, and I will be very careful not to mention anything that I'm not meant to. And I will discuss, first of all, the general reliability. A genuine criminal investigation is meant to be directed at establishing the truth. It is meant to elicit facts in an impartial manner and not to present witnesses with a preconceived idea and to seek confirmation thereof, whether it be by way of leading questions or anything else. By this, I mean that the golden thread linking practically every one of the interviews of the prosecution's so-called insider witnesses, who are, for the most part, ruthless criminals is the a priori targeting of Rodrigo Duterte. In my submission, no real attempt was made to perform this duty of examining exonerating circumstances, or even to establish the existence of other actors who might be responsible for the high incidence of deaths in the context of the war on drugs. Most prosecutors will collate the evidence and thereafter analyze it and decide whether to prosecute with a view to obtaining a reasonable prospect of conviction, which is indeed the standard supposedly applied since Mr. Karim Khan assumed the role of chief prosecutor. A prosecutor is not meant to choose his target in advance and then find the evidence to support a preconceived desire. Now, I'm not going to engage upon a wholesale forensic analysis of the credibility of each and every witness. I am long enough in the tooth to appreciate that issues of credibility and weight are not normally litigated at confirmation, but are left to trial. This case, however, is unique. And as I have said, the prosecution's star witnesses are self-confessed murderers. And most of their statements were taken by the prosecution's investigators with the assurance of limited use. Namely, that anything self-incriminating would not be used against them in proceedings at the ICC. Although Mr. Nichols will undoubtedly tell you that these agreements of limited use are not to be understood as the grant of immunity from prosecution, for all intents and purposes, they are. And I am prepared to wager that we will not see even one, not one, of these incriminating witnesses in the dock at this court, nor in the dock at any court anywhere in the world, after they have been rehoused and given protection at considerable expense to the state parties funding this court. I do not think that I would be alone either in believing that there is something morally repugnant or even questionable from a public policy standpoint to shield not only one, but a number of murderers from prosecution at the ICC just in an attempt to nail Rodrigo Duterte. Indeed, in many common law jurisdictions, the use of a self-avowed murderer to convict an alleged murderer would normally entail vetting and scrutiny of the highest order. Those words, if I'm not mistaken, come from the Crown Prosecution Service's instruction manual. Public source. In fact, I would suggest that it would normally only be approved, firstly, when it is considered of more value to have a suspected person as a witness than as a possible accused. Secondly, whether obtaining the conviction of an alleged murderer is more important than the release of a self-confessed murderer. And finally, whether it is likely that a conviction could be obtained without the cooperation of the self-confessed murderer, or a number of them. Even after this vetting process, most courts in common law jurisdictions require an evidentiary supplement before relying on the sole testimony of a cooperating criminal witness, or what is otherwise called an accomplice witness. Such an evidentiary supplement, in legal parlance, is called corroboration, and rules exist governing what may be deemed suitable corroboration. I'm pretty sure that these considerations were never considered by the prosecution, for one very simple reason. at least two of the most prominent accomplice witnesses were offered up to the prosecution on a silver platter, and I cannot say by who in open session. Neither the Rome Statute nor its accompanying texts regulate the way statements of limited use are employed. I would like the pre-trial chamber to consider the way academics and the prosecution itself has qualified the implementation of limited use statements in the past. And I quote from paragraph 49, which is open source, of a chapter on the Office of the Prosecutor in the 2022 edition of the Max Planck Encyclopedia of International Law, written by no less than Judge Betty Hohler of this court. And I quote, "One of the agreements the OTP may enter into during the investigation is an agreement with a person suspected of committing crimes within the jurisdiction of the court, is to provide a statement of limited use. The idea is that the person provides the Office of the Prosecutor with an oral or written statement for the purpose of pursuing leads or developing additional information or evidence on the condition that the statement will not be used against the interviewed person except as stipulated in the agreement. The purpose of such agreements is to ensure cooperation of so-called insider witnesses whom the OTP does not intend to prosecute, but are expected to provide key information or evidence against other, usually more senior suspects." Judge Hohler was effectively relying on footnote 20 to the prosecution's own filing, number 1118, in the Bemba Article 70 case, which states the same thing. Both sources stress that limited use statements should be used as a rule to pursue leads or to develop information, but not apparently, outright at any rate, to serve as the key and main testimony against a suspect. In my opinion, there is a good reason for this, and it is contained in the wording of Article 54, 3D of the Rome Statute, which is cited as the statutory basis for limited use statements. The prosecutor is entitled to enter into such agreements granting limited use on condition that the agreement would not be inconsistent with the statute. And I stress those words, not inconsistent with the statute. Using the evidence of self-confessed murderers to obtain leads or develop evidence from other sources, I would suggest, is consistent with the statute, as mentioned by Judge Betty Hohler. To give a get-out-of-jail card, however, to a whole bunch of murderers in order to fix liability to another, albeit pre-selected individual, also selected of murder, is, in my opinion, totally and wholly inconsistent with the object and purpose of the Rome Statute, which, according to its preamble, oft cited by the victims and the prosecution, is dedicated to the eradication of impunity. In my opinion, granting immunity to a murder suspect for core international crimes would be seen as undermining the object and purpose of the Rome Statute. Accordingly, I would ask the Chamber to find the statements of those witnesses afforded such limited of use and to be of negligible evidentiary weight. Another issue pertaining to the general credibility of the prosecution's witnesses is the way in which they were recruited. In my opening remarks a couple of days ago, I talked about the general fairness of pursuing charges brought by a prosecutor who was formerly a representative for more than 100 victims of Mr. Duterte's alleged crimes. I also talked about a recorded telephone conversation in which one of the participants bragged about acting as President Marcos Jr.'s silent partner for channeling witnesses to the ICC. Apparently, I raised the presidential spokesperson's hackles considerably. So let me quote a bit more so that I can assure her that my cognitive faculties, which she doubted, are in fact intact. And this is what this covertly recorded individual, who I am forbidden from naming, said. They cooperate through me, since I don't hold a position, redacted. But we are able to do it. So what? What happened here is an ICC investigator will give me a list of witnesses, documents they need to bolster the case against Duterte, then I provide it. I give it to the different agencies so it can be approved. There are witnesses who need a pardon. I get the authority from the President, and they are granted a pardon. Basically, like that, it becomes a priority mission of the government. I don't think I've disclosed here, Madam President, any working methodology of the Office of the Prosecutor. So now I turn to the incidents themselves, the 49 incidents. The prosecution invites you to view these incidents as the manifestation of a much larger pattern. To quote the prosecution's very words, in filing number 330 at paragraph 5, the 49 incidents are a non-exhaustive list of examples of the conduct underlying the charges. Indeed, the prosecution speaks of thousands of victims in toto, data sets, and patterns of violence. Now, the defense does not deny that much drug-related violence did occur. It was occurring before Mr. Duterte assumed the reins of power and continued, as we have shown, by way of a sharp increase after he left office. But these grandiose visions of the prosecution are of no avail if the core criminality and incidents alleged in its document containing the charges are not made out. So the question before you is whether there are substantial grounds to believe, firstly, that each of these specific incidents were unlawful killings, namely deliberate acts of murder, and secondly, that they were knowingly committed to further the criminal objective of the so-called common plan or the state organizational policy with which it has been conflated. And finally, that they are indeed attributable to Mr. Duterte under a recognized mode of liability. Preempting a possible defense, always a good tactic for a prosecutor, unsure of the strength of his own case, there is a heavy reliance on expert analysis of data sets to argue that reported instances of self-defense were statistically improbable. Let me stress that it is the defence's view that if the contextual case depends on the scale of victims, namely thousands, as alleged by the prosecution, then establishing the evidentiary integrity of each charged incident is imperative. In other words, the defence firmly submits that the pre-trial chamber should not commit any one of the 49 incidents to trial unless it concludes that there are substantial grounds to believe that Mr. Duterte's criminal linkage and liability has been established for each one. When these 49 incidents are disaggregated and examined one by one, as the statute requires, we submit, what becomes apparent is not the cumulative strength, rather the recurrence of certain symptoms of inherent weakness in the evidence. These weaknesses fall into 6 broad categories. The first is the over-heavy reliance on the testimony of cooperating witnesses who are inherent criminals with an inherent propensity to be unreliable and whose statements, as I mentioned, are not corroborated by external evidence. The second, hearsay attribution, or in less legal parlance, incriminating statements heard from a source twice or even 3 times removed. The third weakness, which infects the evidence, is the fact that some of the victims are unidentified, making it virtually impossible for the defence to pursue its own lines of inquiry. This weakness affects at least 9 out of the 49 incidents. The fourth weakness, documentary records, such as police and forensic reports, are at variance with and are contradicted by testimony of a single prosecution witness. Fifth, the hoary old chestnut of conflicting statements emanating from 2 or more witnesses testifying to the same event, some contradicting one another, some contradicting even themselves. And finally, the 6th weakness being the repeated absence of any evidence to link the hitmen to our client, despite the prosecution's best efforts to chivvy such linkage out of them. The defence will now show how these identified weaknesses reduce below the substantial grounds threshold the evidence for these incidents. In the 3 counts, as they appear in the document containing the charges. Count 1, the alleged murders during the mayoral period. Count 2, alleged murders of HVTs, the high-value targets, during the presidential period. And count 3, barangay clearance operations also during the presidential period. So I shall start with count 1. As we know, the first cluster of incidents falling under count 1 concerns the so-called and totally fictitious Davao Death Squad period. This concerns incidents 1 through 9 of the document containing the charges. The prosecution's attribution theory here is straightforward, that Rodrigo Duterte, as mayor, authorized killings through intermediaries. But when the evidence for this count is examined, as I've already mentioned, not one witness can say that he heard the mayor give an order to kill. The attribution of criminality to Mr. Duterte arises, for the most part, out of assumption layered on top of hearsay, and follows a repetitive pattern which would, as a rule, entail the same mechanism of attribution. Namely, a hitman witness for the prosecution would state that his handler said that clearance came from, and I quote, above. But what does the word above mean? It means an unnamed superior and nothing more. The mode of liability imputed to Mr. Duterte, namely indirect perpetration, requires the prosecution to establish a stable chain of command through which the common enterprise filtered. If there indeed existed a structured approval process, as the prosecution alleges, one would expect operational consistency, not variability. The incidents contained in Count 1 are also marked by internal inconsistencies which cannot be reconciled and which are indicative of the fragility of the prosecution's overall case. Incident number 1, for example, is based on the evidence of 2 witnesses who contradict each other on fundamental and materially crucial issues. Let me explain in more detail. P26, who presents himself as a participant, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told that it was the mayor on the phone. Was told that the mayor was on the phone. Pure hearsay. The prosecution seeks to reinforce this through P2. Yet P2 was not present at the time. He was inactive, for reasons I can't mention, and relies entirely on what he heard from the redacted third party and another individual at a later date. P2's account is therefore pure, unadulterated hearsay. More significantly, it diverges from P26's version on fundamental points. The year of the incident, 2014 and not 2013. The number of victims, 2 rather than 3. The identity of the perpetrators. The channel through which alleged clearance was conveyed, via driver and bodyguard, to a different DDS member rather than through redacted. And if that is not enough, the method of killing, strangulation rather than stabbing, these aren't minor inconsistencies. They concern the core factual matrix. If the pre-trial chamber is unable to determine even these basic circumstances which establish opportunity, method,
Okay.
Tapos na po ang brain cells namin.
Mga kaibigan, salamat
over to
at
you, man.
alam mo Mido, salamat na lang hindi ako nag-join ng maaga. I think importante na
Actually, Gio, kahit mag-join ka na maaga, my God.
Salamat na lang hindi ako nag-join ng maaga kanina. Buti nga late ako na yun eh.
ridiculousness all over the place, and
Redacted.
I can't stress enough.
Yep,
the
Bito, we've seen enough.
craziness of all this.
We've heard enough.
I think we've heard enough.
Enough,
We
putek.
have.
This
we've
guy,
seen enough.
this lawyer,
Hindi pala,
man.
nabubukan na ako.
Is just running out. I am not kidding. Our brain cells is just running out from
Hoy!
the
He's
ridiculousness of all this.
single-handedly proving the ICC's point. I can't say anything anymore.
I cannot, guys. I cannot. Like,
Wala na to.
I cannot believe how Kaufman absolutely fucked up really hard. I'm sorry, but it's so ridiculous hearing it.
Pwede ba
This is
magsalita
why I
dito?
walked out.
Pwede ba
Ayan
magsalita
na.
dito?
Please welcome our TOC LTG. Let's go.
Okay. The fact that they have to rely to a Chewbacca defense is just mind-boggling. Why? Why?
You were actually
Hindi,
saying
wala
that
akong
as a
masabi.
joke kanina. You were saying that as a joke kanina.
Tragis.
I'm saying this as a joke. Tinatohanan talaga niya. I'm actually just saying that as a joke. Wait. May may feed na ulit tayo. Balik ulit tayo for the hearing.
Okay.
The statute
Tiisin
does
na lang
not
natin
permit
to.
charges
Tiisin na
to
lang
be
natin
confirmed
to.
on the basis of conjecture, on the basis of such a weak evidentiary basis. Now, since the prosecution made such a big deal out of incident 3 on Monday and screened the video of the hit job itself, if you recall, the one in a marketplace which was supposedly viewed with approval by our client, I would like to devote a few words to it. If your honours follow the transcript that accompanies this video viewing session, the prosecution fixated on the comments of Mr. Duterte telling the person operating the video not to zoom in.
Nawala na naman po tayo, guys.
Well deserved. Well
Ayun na naman
deserved.
po.
Has he been redacted from the last few hours that he's been presenting his
Question
case?
ko lang, Epstein files ba to or
At
hearing
least
ni
may
Duterte?
na-redact na naman si Kaufman for the nth time.
Wala
Tanong ko lang, mapatanong lang, Epstein files ba to or ICC hearing?
Wala masabi dito as in kasi every time nagsasalita siya after like ilang minuto redacted na.
He just keeps implicating himself. That's the problem. He's not even trying to defend his own client. That's the problem.
Ang ad hominem eh, puti.
And we're respecting.
Ang ad hominem, he's doing the classic TDS attack playbook.
It's like playing his victim
Ay,
card.
Again.
Mamikom tayo, mag-MVP tayo Ano lang.
Actually, yung mga rebuttals si Kaufman, that's what I actually deal with the DDS last month. That's exactly what I dealt with. Kung wala silang maisasagot, nang ad hominem sila. Yung ginagawa ni Kaufman is pretty much below the belt. And as for a freaking lawyer with experience, sa totoo lang,
Walang masabi
Sabi ni
dito
Athena,
talaga.
they still win with this. And I do agree kasi still money. It's the win-win situation, baby. They will probably portray Duterte as a sympathetic political prisoner. Mga ganon.
Unang-una, bakit siya
tinatry
nare-redact?
niyang mapalaya, ganon.
Eto. May naisip akong opinion for this. I think
Go, LTG.
tinatry niya na i-redact yung feed para ipakita talaga na they can do that, na kaya nilang i-persuade yung by redacting the freaking ma-persuade parang mali yung mali yung ginagawa ko kahit na mali ginagawa ko gagawin ko pa rin siya.
Ridiculous.
Like why? Why do we do that?
Ridiculous for him as a professional lawyer.
Ang tanong, 'di ba code of ethics 'yan? Ang tanong, is that a grounds for disbarment?
Pwede.
That is the question. And also, it looks like I'm watching like Better Call Saul rather than a freaking trial.
John Buchanan can defend better than that guy.
That-
My God.
Sina based from
If you know
Cambridge.
SVU.
Based from Cambridge, si Kaufman. He studied law there.
And would it be
Hindi
like
na ako
grounds
magugulat.
for disbarment? Yung
Yeah,
mga
it can
ginagawa
be.
niya? Or is it just like a tactic?
Not gonna lie, it can be a grounds of disbarment kasi nagsasabi siya ng victims censored names na dapat hindi sabihin sa public court. 'Di ba? Dapat
Yeah.
hindi sabihin sa public court and
For the
sinabi
safety
niya,
of the
That's,
victims.
by the way, watched by international media. That's the problem.
not
Yeah.
local, by the way, not local. We are watched by
Not just
international media.
not just local media, international media are also there sa loob ng gallery watching the whole proceedings, and they see Kaufman doing something like
Doing
that,
that.
which
Doing that.
we're seeing it as a very, very tactical move to like persuade supporters within the circle of the former president. What is actually going to happen dito sa ating dito stateside for regarding the perception of the former president?
I am just baffled na bakit niya ginawa 'yon. And
You should
ang
know
ganda
better
ng
as a lawyer.
ang ganda ng day 1, day 2
And
natin tapos sinira niya ng day 3. Diba masabi ko?
Okay lang, we'll redeem day 4.
well, I can already see a redemption for day 4. I can already see a redemption for day 4. But
my
I don't
head
know,
hurts.
like I don't know how we could.
Well, yung stream
I will
natin
be
nawala.
honest with our viewers right there. I don't know how we could possibly save that coverage.
Well, yung stream natin
I
nawala.
will be
Wait a
honest.
second.
I don't know how we're going to save whatever just happened at the pre-trial chamber 1. It is
It is just ridiculous. Hanggang ngayon, guys, wala pa rin tayong feed. So I think we need to go for a break for just like 3 minutes or so. So para
Are
makapag-fresh
we
up
like
tayo.
going
So,
to commercial break?
Should we?
Should we?
Should we? I think we
Habang
are kasi hindi
hinihintay
pa
Alright, I
natin.
think I said we go on break.
Yes, we have to go to
Yes,
break. I think
mag-break
kailangan nyo to
po.
for your
Ayan.
mental sa inyong
mental
brain
health.
cells nyo to, for your brain cells
Sanities
to.
din.
Sa
Ayan,
sanity ninyo
magbabalik
yan. I
po.
think importante sa inyo mag-commercial kayo. Sige, kayo
Pwede
eh.
ba magsabi
Tayo
Ayan,
ng
magbabalik po
magbabalik
sa ating
po.
special
Ayan na
coverage.
guys, kalma. Ayan, magbabalik po ang new special coverage ng confirmation of charges ni dating Pangulong Rodrigo Duterte matapos po ang ilang paalala.
We will be right back.
Dito na tayo sa JA, kung saan lahat ay okay. Sa JA, Lahat ito ay super mura. Lahat mga maganda dito sa JA. Sa JA, napatunayan na ng bayan, wala namang iba. Quality shopping ang aming dala. Mapapa-JA talaga kayo. Ang supermarket namin ay JA.
Every sunrise brings a new story, and every story begins with a single journey. At Zakish Airlines, we believe travel isn't just about reaching your destination. It's about the experience that carries you there. From comfort that feels like home, to service that feels like family, we make sure your moments in the sky are unforgettable. Because when you fly with us, the world is closer than you think. Zakish Airlines, your world within reach.
Innova Power G6. Fast, sleek, reliable, affordable. Now equipped with Ryzen 7000 series CPU, Radeon RX 7000 series, 1TB SSD storage, and 32GB RAM. Enough to fulfill your needs.
Innova.
Di biro ang maging newscaster at president and CEO. Dati, sa office inaantok pa ako at napapagod. Buti sa tulong ng Lion Energy Drink, lumakas pa ako. Bukod sa taurine, vitamin B complex at ginseng, ay meron ring vitamin C para lumakas ang immune system. Kaya ako'y matibay at masigla ang aking trabaho. Lakas ka with Lion Energy Drink. From Godwin Enterprise.
Mahalagang paalala, ang Lion Energy Drink ay hindi gamot at hindi maaaring gamitin pang gamot sa anumang uri ng sakit.
Iron, taurine, and B vitamins is the key for PD Cola.
PD Cola!
25 pesos lang, sang ka ba?
Pagkagising sa umagang umangon at kumain ng sapat. Gatas ang kailangan para lumusog ang katawan, pero may solusyon dyan. Ito ang MSI Gatas. Uminom ng MSI Gatas.
Ada Morella po, mag-MSA Gatas para iinumin ang gatas. Sarap. Mag-MSA Gatas na. 69 na piso SRP sa suking tindahan.
The use of milk supplements must only be upon the advice of a health professional.
Wala kaming commercial. Pwera na lang sa commercial nito, oo. Oo naman. Pero, meron ba kaming bagong produkto? Meron ba kaming iaalok sa inyo? Meron ba kaming kinuhang artista o sikat na personalidad para i-endorse kung anong mang inaalok namin? Siyempre, ang sagot niyan, wala. Literal na wala. Wala kami niyan, Chong.
At nagbabalik ang koolNews special coverage ng confirmation of charges hearing ni dating Pangulong Rodrigo Duterte. Ito ang Duterte sa ICC. At mukhang since hindi na rin namin kaya mag-analyze ng mga nangyayari dito sa ICC at wala na ring feed at matatapos na rin ang mga kaganapan doon ay dito na muna magtatapos ang aming programa. Ito po ang Duterte sa ICC, ang ikatlong araw ng confirmation of charges hearing ni dating Pangulong Rodrigo Duterte. Ako, si Midori Tachibana, sa ngalan ng buong pwersa ng koolNews, maraming salamat at manatiling nakatutok sa Kool FM para sa pinaka-huling updates. Magandang gabi. Susunod na, ang Talk with Sen.